Hi, my name is Caroline Rouleau, and I'm with my colleague Stéphane Reynolds. We're both lawyers at Kin-Lamar. Today, in this short video, we'll discuss some key principles that municipalities should have in mind uh, on the subject of splitting municipal contracts.
Thank you, Caroline. So, under Quebec law, cities and municipalities are required to award contracts whose value exceed a certain threshold by selective tendering or a public call for tenders. You're already familiar with that. As such, the principle is that it is forbidden to circumvent these public policy requirements by splitting a contract into multiple smaller successive contracts so they can be awarded to a specific company that we choose. There's a specific provision in the Municipal Code of Quebec, and there's the same in the City of and Town Act, that stipulates as follows. A municipality may not divide into several contracts having similar subject matter: an insurance contract, a contract for the performance of work, a supply contract, or a contract for the supply of services other than professional services necessary for the purpose of a proceeding before a tribunal or a body or person exercising judicial or adjudicative functions, unless the division is warranted on grounds of sound administration. But, Caroline, what exactly constitutes an illegal division?
To give you an example, recently the AMP, Autorité des Marchés Publics, made a recommendation to a regional fire authority that touched upon the division of contracts. The regional authority launched a call for tenders for the construction of a fire station. It received 3 tenders, but did not award any contracts since the AMP obtained information that suggested that the call for tenders contained a condition that was illegal. So first, the call for tenders contained the obligation for the successful tenderer to subcontract with a specific architectural firm who worked on the plans and specifications for the fire station. That subcontract was in the amount of $450,000. Secondly, it was brought to the AMP's attention that the preparation of the plans and specifications did not lead to any call for tenders. The same goes for any supervision or services rendered during the construction work. So the AMP confirmed that the tendering process was illegal for various reasons in that case. Namely, the contract for architectural services had been divided in 3 different contracts. The initial proposal for those architectural services was in the amount of about $600,000. But in reality, there was one contract awarded directly by the board, by the fire authority, to the architectural firm before the call for tenders for the construction of the fire station. That contract was under the tendering threshold. Another contract was concluded between the firm and the consultant whose services had been retained by the fire authority. Again, this contract was below the tendering threshold, so was for a smaller amount. And then the third contract was the one planned in the call for tenders in the amount of $450,000 approximately, and that was the subcontract that the successful tenderer would have to enter into with always the same architectural firm. So according to the AMP, the division of contract was illegal, and it was clear that the parties intended to circumvent the prohibition and the law and avoid competition between firms. Also, the fire authority could not include a condition in its tendering process that would oblige to conclude a contract with the specific firm, especially in the amount that is above the tendering threshold. The division wasn't warranted by any grounds of sound administration in that case.
There is also a decision in 2011 where the Superior Court ruled that an elected official as to be disqualified from holding office for knowingly dividing a work contract into several similar contracts. In this case, the contract, which included hours of machinery use like excavator, tractor, etc., was divided in two periods. The first period ended on August 24, and guess what? The second began the next day, August 25th. So both invoices fell under the 25,000 mark. So the municipality was able to give them to a company chosen by the municipality. Moreover, a single check was issued by the municipality for both invoices. This is a clear example where the division of a contract is not justified on the ground of sound administration. There are some cases where division has been deemed legal. So, Caroline, talk to us about that.
For instance, in 2017, the Court of Quebec ruled that a city had concluded multiple successive contracts by mutual agreement for the purchase and delivery of asphalt. All the deliveries made were made during an orphan period. That is, between two periods covered by contracts awarded following a call for tenders. However, the city refused to pay for the material delivered on the grounds that a call for tenders was warranted, given the amount of the overall expenditure over all the orphan period. The court rejected the city's argument and position and concluded that there was nothing in the evidence submitted that suggested that the parties intended to circumvent the law by dividing one contract into multiple contracts. The duration of the orphan period was indefinite, since it was not known when the new contract would be awarded. It was therefore impossible for the city to know its needs and to conclude one contract for the whole period. In addition, even if the division were to be illegal at first glance, the court deemed that it was based on grounds of sound administration, the division made sense and was justified because ensuring the safety of public roads was such a ground.
Talking of sound administration, the courts have also endorsed the approach of dividing territory into sectors for the purpose of awarding contracts for matters like snow removal and waste collection for a reason, a purpose of efficiency. This type of contract can therefore be split into separate contracts for specific sectors. Generally speaking, the municipality would still proceed with one or more calls for tender and offer tenderers the opportunity to submit prices for each or all of the option or for just one territory in which they are tendering.
Lastly, we want to bring to your attention that the rule prohibiting the splitting of contracts is reiterated in this new law that the name is an act respecting contracting by municipal bodies, which is not yet into force, but was enacted in March 2025. This law will come into force at a date to be determined and is expected to come into force in the spring of 2026. We invite you to be wary of splitting a contract into several smaller contracts, as this might circumvent public policy rules that apply in municipal contract management. So if you have any doubts about the legality of your approach, don't hesitate to ask your legal advisor.
Thank you for your attention.